Dear participants, as president of the European Law Institute, it is with great pleasure that I welcome you to this webinar series that ELI has embarked on with the American Law Institute. It is the first of many, I hope, such transatlantic series, and we are particularly pleased that it has taken off this year on ALI's centennial. The European Law Institute is an independent, non-profit organization established in June 2011 to initiate, conduct, and facilitate research, make recommendations, and provide practical guidance in the field of European legal development. The idea for the ELI was directly inspired by the activities of the American Law Institute, though with a kind of European touch. As a think tank, ELI is a broad network of over 1,700 members from various vocational backgrounds. Among our members, we have over 145 institutional members, including the European Parliament, the highest court in the European Union, the Court of Justice of the European Union. We have the UNCITRAL, almost every Supreme Court in Europe, several law firms, faculties, and professional associations, including the Council of Bars and Law Societies of Europe, the Council of Public Notaries of the European Union, the European Network of Councils for the Judiciary, and the network of the presidents of the Supreme Judicial Courts of the European Union. ELI's work is primarily conducted through projects which are run under three pillars. The first one, the rule of law and the convergence of legal systems in the 21st century. The second, law and governance for the digital age. And third one, sustainable life and society. We are currently running 14 projects. And last year, we concluded 6 projects outputs, 4 responses to European Commission consultations, a resolution on Ukraine, and an innovation paper. This shows the dynamism of the European Law Institute. One of many examples of the impact of ELI's work is shown by the joint project conducted with the American Law Institute between 2018 and 2021. The ALI-ELI principles for a data economy have not only triggered deep interest from a whole range of states, but rather these principles have had an impact across the globe, as will be testified by representatives of leading organizations, as well as by the architects of the principles. As a result, ELI and ALI look forward to embarking on further joint efforts in the future. For now, I invite you to join us not only for today's webinar, but also for other webinars in the series in the course of 2024 on automated decision-making and consumer law, third-party funding of litigation, and the digitalization of justice systems, and probably further ones. Without further ado, I turn now to the president of the American Law Institute, David F. Levy, for his introductory remarks. Thank you very much for your attention.
Thank you, Pascal. I begin by thanking you and the ELI for partnering with the American Law Institute on this webinar series, and also thank the attendees who are joining us to learn more about the ALI-ELI principles for a data economy. The ALI, like the ELI, is a membership-based, independent, nonprofit organization with the mission of providing guidance to courts and others on important legal developments and of furthering the rule of law through reform, simplification, and clarification. Although the ALI was initially focused on clarifying U.S. domestic and common law, we have produced work on many other subject areas over the past 50 years, including international law, beginning with the restatement of the Foreign Relations Law of the United States, published in 1965, to the recently published restatement on the U.S. law of international commercial and investor state arbitration. Although ALI's increased interest in international law was an indicator that a partnership between our two institutions could yield very good results, we could not have predicted with any certainty just how successful the data economy principles would be. The goal of this project was to study, identify, and collate the existing and potential legal rules applicable to transactions in data as an asset and as a tradable item. When the ALI and ELI launched this project, we knew that this objective was ambitious. The aim was to make recommendations and to provide practical guidance in the burgeoning field of data economy to courts and legislatures worldwide. This was bold. You will learn today that this project not only accomplished its goal, but exceeded it in quality and clarity of the final product. You will hear from the project's co-chairs and reporters, and we will also be joined by leaders of international organizations and corporations who have relied on the publication for guidance. This achievement was only possible because of the partnership between our institutions, the outstanding leadership of our reporters and co-chairs, and the wisdom and guidance provided by the project participants. I salute you all. As President Pichonaz mentioned, this year ALI celebrated its 100th anniversary. As we move into our second century, we are excited about our future and look forward to additional partnerships with the European Law Institute. I now turn the program over to our ALI project co-chair, Steve Wise, who has done so much for this project. Thank you all.
Hi, everyone. I'm Steve Wise, and as I was co-chair of the project on behalf of the American Law Institute. Thank you very much, Pascal and David, for your introductory remarks, and thank you for all of you attending for joining us on this program. We are quite excited that after all this work, we actually now have an actual book of the principles that is just coming from the publisher. I think the first boxes actually arrived today and will soon be available for acquisition, whether through your libraries or however you might want to do it. Let me mention that the book, in addition to the black letter, which we will provide as part of the materials for this program, has extensive explanatory comments and reporter's notes covering both European and United States law. So it's extremely valuable as you work or think about matters in this area. In addition to the black letter, the materials will include a guide to the principles co-authored by the four of us and several other people who work closely on the projects. I think you'll find it altogether quite informative. Let me cover one administrative matter for those of you in the United States who want continuing legal education credit if your state bar organization requires confirmations. For those of you, there'll be two requirements, excuse me, to get that credit. First, several times in the course of this program, there'll be little questionnaires popping up on the screen. We'll alert you requesting a yes/no kind of answer. Please answer that and submit the question. You'll have 10 seconds each time to do that. It takes a lot less than 10 seconds to read the particular questions. But again, for CLE credit, that will be your method of confirming that you attended the program. In addition, for the United States participants, with the course materials will be a form to fill out. You're all used to this form to confirm you attended and things like that. So I'm now going to turn over to John Thomas. John was the former Lord Chief Justice of England and Wales and was the other co-chair of this project on behalf of the European Law Institute. So John, please go ahead.
Good afternoon and good evening. May I welcome you all to this webinar and say, first of all, what an immense privilege it has been for me to work with Steve as co-chair and Christian van der Horst and Neil Cohen as the great reporters who put together this fundamentally interesting and revolutionary set of principles. I've used the word revolutionary because I think they are. When you look at data, you realize that you're dealing with something quite different. I'm not going to try and explain to you why it's different now, because that would bring the purpose of the webinar to a premature conclusion. But what we hope to do during this webinar is to explain to you why this is so important, why you need to understand the future of law in this area, which is of immense economic importance, and how, above all, the work of the two institutes has produced something that is transnational in its flavor, that we believe it will work as a set of principles worldwide. And that is the purpose of this webinar tonight or this afternoon, wherever you may be.
Alrighty, thank you,
Now
John.
I'll hand back to Steve to give the first of the poll questions.
Yeah, so here's our first question. It'll come up on the screen. Again, if you're an attendee from the United States, you must answer all four if you want CLE credit. So the first question is, before today, had you heard of the ALI-ELI principles for a data economy? Please click and submit.
And while you're doing that, can I say one other thing? You'll see at the bottom of your screens a Q&A. We'll be taking Q&As at the end, so please start filling them in now as we go through this.
Okay, there was our first question. So now we're going to go into our an additional video. You'll see as we go through this that our program is a combination of presentations by us on this, briefly reviewing the substance of the principles, and videos from various participants on how their organizations view the principles. One key theme you'll see throughout all of this is that it was not just a bunch of us sitting in a room someplace thinking about this, but we got a lot of input from a lot of different organizations, and it's very important to have that input because, as John said, there are no borders on the data, and all of this has to work in different countries, different institutions, and different industries. So our first video is from the Secretary General of the United Nations Commission on International Trade Law, Anna Jobin-Brett. UNCITRAL does lots of model laws and similar kinds of projects, as she'll explain. And the data principles that we're here talking about today were an important contributor and incentive and getting the ball rolling for UNCITRAL. So why don't we hand it over to the video for Anna.
Dear colleagues, dear friends, it was almost 5 years ago that I sat down with Professor Neil Cohen and Steve Wise to discuss a new joint project between the ALI and the ELI on data contracts. The enthusiastic exchanges that I had on that cold December day in Vienna when I had just landed in UNCITRAL with these two wonderful experts and longtime friends of UNCITRAL confirmed in my mind that any effort to find international harmonized solutions to the application and adaptation of commercial law in the digital economy cannot ignore data transactions. Since then, the Secretariat of the United Nations Commission on International Trade Law, whose mandate is precisely the progressive harmonization and the modernization of the law on international trade, has had the privilege to watch the principles for a data economy develop. During this time, the Secretariat had its own work cut out for it, having been mandated by the Commission in 2018 to explore the legal issues related to the digital economy. Like the ALI and ELI councils, the Commission recognized the need to examine the legal aspects of cross-border data flows alongside other topics such as the development of artificial intelligence and the digital assets supported by distributed ledger technology. I'm pleased to say that the synergies between the ALI-ELI project and UNCITRAL's work program and the interactions and the support we received from the ALI-ELI team have continued well beyond the finalization of the principles in 2021. Last year, on the back of proposals emanating from that earlier exploratory work that I mentioned, the Commission agreed to mandate its e-commerce working group to start work developing an international legislative text on what the ELI principles call contracts for the supply or sharing of data, and that we called data provision contracts. The ALI-ELI principles played a significant role in getting us to this point. The experience of Ancitral has shown that solutions finding acceptance in both the North American and continental European legal systems augur well for including the topic on the work program. So the successful finalization of the principles provided a compelling case to Ancitral delegates that the topic of data provision contracts was amenable to international harmonization and the consensual development of a legislative text, and was thus ready to be referred to a working group. But more profoundly, it is the content of the principles and the accompanying commentary and reporters' notes that have helped to identify and elucidate the problem within the working group and to inform the contours of possible legal solutions. In that regard, in the data section of the legal taxonomy that the Ancitral Secretariat has just published on legal issues related to the digital economy, we could not help but cite the observation of the introductory note, to the principles that both in the United States and in Europe, uncertainty as to the applicable rules and doctrines to govern the data economy is beginning to trouble stakeholders, end of quote, and that, I quote, this uncertainty undermines the predictability necessary for efficient transactions in data, may inhibit innovation and growth, and may lead to market failures and manifest unfairness, in particular for the weaker party in the commercial relationship, end of quote. I could not agree more. It has been a privilege for my colleagues and I to welcome Professor Christiane Wenderhorst and Professor Kohn as observers to the working group, where they clearly and adeptly explained the principles in preliminary discussions last year and shared lessons learned from the experience working on the principles. I look forward to the continued involvement of the ALI and the ELI in the project as the working group reconvenes next month to consider a revised set of default rules on data provision contracts. Colleagues and friends, congratulations once again to all those involved in the development of these unique and important principles. Well, may we celebrate the opportunities and excite in the challenges of the data economy, but there is still nothing quite like the launch of a printed edition. While in this form, its content may fall outside the scope of the principles themselves for want of machine readability, it is the human readability of the printed edition that will no doubt help to propagate the principles in North America, Europe, and beyond. Count on us, and thank you for listening.
And thanks to Anna for her comments. Her comments emphasize one aspect of the importance of coordination of this project and similar kinds of projects in other organizations and groups, so that we're all working from, to use the cliche, the same page, although it'll be a digital page, no doubt, that we're talking about as we work our way through these projects. Our next speaker on video is Atsushi Koide. He was the delegate from Japan to the project at Ancitral that Anna just described. And as he will describe in his comments, Japan has very extensive, very detailed provisions and regulations in this area. And those were very helpful and informative for the Principles Project to see how it worked. And again, further efforts to coordinate among international organizations, governments, regulators, academics, practicing lawyers, and the like. After his comments, Neil Cohen, the co-reporter on the project from the American Law Institute, will provide some observations. Neil is a recently retired professor from Brooklyn Law School who has taught in the commercial law area, this area, for longer than he cares to remember. So why don't we go to the video, please?
Dear attendees, my name is Atsushi Koide, Professor of Commercial Law at Waseda University in Tokyo. It is a great honor to be given the opportunity to address from Japan to congratulate the ALI and ELI on the official publication of the Principles for a Data Economy. I learned about the ALI and ELI project on the Principles for a Data Economy through discussions on data provision contracts at the United Nations Commission on International Trade Law, UNSTRAL, Working Group 4, in which I am currently representing Japan. At the session of the UNSTRAL Working Group 4 and at the joint expert meeting hosted by UNSTRAL and UNIDROIT, I had the opportunity to hear Professor Christian Benderhorst explain the draft principle. The ALI-ELI principles have been repeatedly referred to as a starting point for discussions in the ongoing UNSTRAL project on data provision contracts, and I personally have a great theoretical interest in the framework of the principles. The ALI-ELI principles are also attracting attention in Japan. A paper introducing the final draft of the ALI-ELI principles in Japanese has already been published, and the principles are mentioned in several articles. Interest in legal issues related to data transactions is increasing all over the world, and Japan is no exception. For example, as noted in the principles, the Ministry of Economy, Trade and Industry, METI, of Japan published contract guidelines on utilization of AI and data in 2018, which were revised in 2019. The ALI-ELI principles released in this context will attract even greater attention internationally. From my perspective as a Japanese legal scholar, I think that the principles are of extreme interest even to non-ALI-ELI member countries in the following 3 points. First, the issues that the principles consider to be problematic with respect to data contracts and the approach to those issues are similar to those in Japan. In the digital age of business, the value of data as an intangible asset that creates new value is increasing. However, since data is different from the traditional property, there is a lack of accumulated practice on contracts regarding data, and gaps in recognition and understanding exist among parties and stakeholders in data-related transactions, resulting in huge contracting costs. The METI guidelines were prepared with the aim of reducing such transaction costs and promoting the data contract and the effective use of data by presenting the legal issues and discussion points for each type of data contract, as well as indicating factors to be considered when concluding such contracts. While the ALI-ELI principles are intended not only to provide a model for contracting parties, but also to serve as a legislative guide, and its scope seems to be broader than the METI guidelines, I believe they share with us the basic goals and approach. Second, I think that the principles take a step forward with respect to the default rule for data contracts. The METI guidelines are based on the idea that the purpose of a data contract is to facilitate the use of data by the parties and to appropriately distribute the revenues generated by the use of data among the parties while taking into account investment incentives. And since who contributed to the creation of data differs from data contract to data contract, the METI guidelines stress the importance to agree in the contract on who can use which data and under what condition, rather than setting default rules for data ownership. The principles, on the other hand, seems to have a clearer attitude about the default rules for the right of each party to a data contract. We can learn a lot from these default rules and the analysis of them in the principles. Third, the ALI-ELI principles have an innate international origin. The principles cover both civil law and common law legal system and are not dependent on any particular legal system. Therefore, the legal issues presented therein provide useful insights for countries that are not members of ALI or ELI. Of course, there are many differences between the ALI-ELI principles and METI guidelines, for example, the categorization of data-related contracts. However, I believe that these differences will provide an opportunity to deepen the legal discussion on data contracts and to enable mutual understanding and harmonization of the law on data contracts. The ALI-ELI principle and the various initiatives around the world, including the METI guidelines, are by no means libelous. Once again, I congratulate the release of the ALI-ELI principles and look forward to future global collaboration. Thank you.
And thank you very much, Professor Koide. Your views on the subject of the ALI-ELI principles, informed by your experiences in Japan, which has been a leader in thinking about these topics, is very important to us. As you mentioned, Japan's Ministry of Economy, Trade, and Industry published contract guidelines on the utilization of data in 2018 and revised them in 2019. These METI guidelines, as they are often called, were an important resource for ALI and ELI in producing the ALI-ELI principles. While the METI guidelines are fashioned and organized as a guide to contracting parties rather than to lawmakers, the identification in the guidelines of issues of particular importance in data contracts that should ideally be addressed by bargaining between the parties provided a template for our consideration of issues for which contract law should provide an answer in the absence of such bargaining. In other words, the development of default rules. Moreover, our development of these default rules, rules subject to freedom of contract between the parties, recognizes that often the best way to achieve a balance of rights between data suppliers and their recipients is by private ordering. The ALI-ELI principles, using a functional approach, identify 9 different types of data contracts, 5 for the supply or sharing of data, and 4 for services provided with respect to data. And working from a common template, the principles recommend default rules for each type. You can see a list of these types of data contracts on pages 8 and 9 of the guide to the principles that is included in the materials for today's program. The default rules identified in the principles for each type of contract share a common organization, but differ from each other in light of the different functions of those contract types. With respect to contracts for the supply or sharing of data, they allocate responsibilities and risks of the parties in default rules that are seen as appropriate both from a sense of commercial policy and the likely expectations of the parties. The UNCITRAL working group, about which you heard a bit earlier in the remarks of Anna Jobin-Brett, has in turn used the first 5 contract types, those about the supply or sharing of data, as an inspiration and resource for its ongoing work on data provision contracts. Now, before we turn to our next speaker, we need to take care of some CLE business. And you will now, or in a moment, see the second poll on your screen. There it is. As a reminder to US attendees, you must answer all 4 polls. Our question here is, does it surprise you that this project has garnered this level of international attention? You have 10 seconds to answer. There we go. Our 10 seconds are up. Now I'm happy to present remarks from Sarah Dodds-Brown, Executive Vice President and Deputy General Counsel at American Express, who participated as a valuable advisor for this project, and in particular, was an important resource in our development of a framework of best practices and model provisions for contracting parties to draw upon. Sarah?
Greetings to the members of the American Law Institute and European Law Institute. My name is Sarah Dodds-Brown, and I am Executive Vice President and Deputy General Counsel at American Express. I participated as a project advisor on the ALI and ELI joint project to develop principles of a data economy. The principles keep front of mind the strict data protection regulations, such as GDPR and other types of rules that the EU Commission would issue. This makes them workable and relevant across the approaches taken by different jurisdictions, which is a plus for global companies looking to develop a uniform and principled approach to data transactions. The principles transparently aim to address the natural overlap and ambiguity between different bodies of law that may apply to data, including privacy and data protection, intellectual property law, or trade secrets law. Over the course of the data economy project, the intentional purpose and scope of the principles evolved, and the project advisors leaned into the idea of providing a framework of best practices and model provisions for contracting parties to draw upon, and guidance around how parties should think about the interpretation and application of contract law in the context of data transactions. The default provisions outlined in Chapter B provide a broad framework of data usage rights and obligations of varying degrees for both suppliers and recipients of data, depending on the mode of access. These are designed to encourage innovation and a robust data economy, with the expectation that parties would negotiate further contractual rights and restrictions as appropriate. The principles also helpfully include a number of different models outlining how data usage and access relationships may arise, like data pooling or give-to-get arrangements, code-generated data, data trust and escrow concepts, and data marketplaces. By having a variety of construct examples, it allows parties to identify the most relevant analogies for their business and to flexibly adopt elements of the principles. We use contract language to try to allocate rights in a way that is philosophically consistent with these principles. And because of their flexibility, they are adaptable to be able to accommodate new technologies and innovative business models. The approaches that have arisen in regulatory constructs, both enacted and proposed, in the EU, Australia, and now the US, are complementary to the foundation that the principles set out. This coalescing around ways of allocating rights and risk as it relates to data has helped to organize how commercial parties can approach their negotiations and expectations with respect to data transactions.
And thanks to Sarah for those comments. And again, as we've been talking throughout this, Sarah's involvement in the project, along with other people from different industries where data is used a lot, emphasizes the importance, again, that what the principles developed were workable, both from legal and regulatory perspectives, but from the actual users of the data, so that the rules that came out, or the principles themselves, work in real life. Now, Neil spoke about some of the contract aspects, and in a few minutes, Christiane will speak about data rights. And I'm going to spend just a couple of minutes here talking about third-party effects. So we've got a lot of discussion by Neil and Sarah about allocating by contract, freedom of contract rights and duties and obligations of the parties. But of course, third parties might be affected, and there are a set of rules in the principles that address third-party rights. Keep in mind that there may be somebody who produces the data, there may be someone who controls the data, and then there may be a recipient of the data, and there may be downstream, onward recipients of the data. And what if somebody has not complied with their own obligations under their contracts, under intellectual property law, under privacy laws, and things like that? What effect does that have on third parties who are not parties to the contract, on third parties who did not themselves breach a regulation or breach a contract or something like that? And the law is full of rules about holders in due course and negotiable documents and things like that. And the question here is how to apply those concepts of predictability, reliance, innocence, as it were, in these various contexts. So there are a set of rules that are tailored to the data industry, the types of data that address when third-party rights are protected, when third-party rights are not protected, what people know, what people should know. And it works its way through a series of hypotheticals and possible constructs to try and weigh the various interests of reliance, fault, public policy, and other types of concerns to come up with an approach that is fair across the board, both to the direct participants in the transaction and to others who may be affected by the transaction, but themselves are not direct participants in the transaction. In the guide, starting on page 15, the guide works its way through this. There's some very helpful diagrams and charts in the guide. Christian gets almost all the credit for putting together those diagrams and charts. They're super helpful as you try to understand some of this new terminology and where different persons fit in the flow of these transactions. So strongly encourage you to take a look at that as you try to work your way through all of that and understand what the risks are, and as you allocate risk, as described by Neil and Sarah, keep in mind that what the contract says is great as between the parties to the contract, but may not necessarily control the rights, obligations, duties of third parties to the contract. So we're now going to have a video in just a moment from Dirk Studemeyer from the European Commission. And as I've been repeating myself over and over, it was important that everything the principles covered were coordinated and functional and feasible with regulatory and government authorities. And as you'll hear in a moment, the European Commission, of course, plays a key role in all of this and is very interested in that. At the time Dirk recorded this, which was not very long ago, the Commission was considering what's called the Data Act. It's now been adopted by the Commission. So this is very real in the world out there in transactions and in particular in Europe. After Dirk completes his comments in the video, Christian Venderhorst, who was the co-reporter on behalf of the European Law Institute and is a professor on the law faculty at the University of Vienna and the past president of the European Law Institute, will have some comments, and then we'll also provide an overview of the rights, party rights, party rights, and data rights. And so why don't we go to the video, please?
Good morning, ladies and gentlemen. Thanks to the European Law Institute and the American Law Institute for this invitation to send this video message at the occasion of your webinar on the impact of the ALI-ELI principles for a data economy. It has been said that in the 21st century, data are the most important production factor, more important than real estate and machines. And accordingly, the European Commission emphasizes that data are at the center of the digital transition. Now, private law, as part of the regulatory framework, can promote this development and at the same time safeguard important elements of our market economy. Now, the central question of the data economy to which the private law has to find an answer is who has access to data and under which conditions can one use them commercially. That concerns both the consumer side and the business side of the data economy. So for instance, for B2C, shall the consumer have an economic advantage if they grant access to personal data? And if so, what should that be? And how could that be designed legally? Or should a company have access to data which are held by another company in order to develop new data-based products or services? At present, the private law of the data economy is developing rapidly, and the principles are an important part of it. Now, the title of your webinar is The Impact of the Principles for a Data Economy, and indeed, the principles had and continue to have an impact. I noted, for example, in the notes on Principle 5, the quote, "It would not come as a surprise if in the future EU Data Act, a proposal for which is announced for 2021, mandatory rules or blacklisted terms for B2B relations were included." End of quote. Now, the Data Act will be adopted on the 27th of this month, in 2 weeks. My unit worked on the private law part of the Data Act. And in addition, my unit is chairing the work of an expert group preparing model contract terms for data sharing contracts and cloud computing contracts. And this work will feed into the Commission recommendation foreseen in the Data Act for this purpose. And I can tell you that the principles for a data economy had and continue to have an impact on the Data Act and this follow-up work. There are three waves of developing digital private law in the EU. The first wave in the 90s was adapting EU private law to the e-commerce development. The third wave will deal with the impact of AI. At present, we are in the second wave, regulating new business models of the data economy. For instance, the Digital Content Directive recognizes that data are a counter-performance in contracts on digital content and digital services. Or the Sale of Goods Directive regulates the sale of products with digital elements. And in this wave, the Data Act regulates, among others, the contractual relationships between data haves and data have-nots. So to conclude, at present, we're seeing important steps towards the private law of the data economy. Your principles help that legislative initiatives like the Data Act and the initiatives following the Data Act do not travel into uncharted territory. Congratulations for this extremely useful and successful work. The impact of your principle is significant. Thank you very much.
Yeah, thank you very much to Dirk Staudenmayer from the European Commission. I'd like to add a little bit to what Dirk has been saying. Dirk has been focusing a lot on the significance of the principles in the field of contract. And indeed, the principles have influenced what the Data Act says on contractual relations about data. And I'm now a member of that expert group of the European Commission that is drafting model contractual clauses for parties in the data economy. And the principles are very useful for that work. What Dirk didn't mention, maybe because it was too obvious, is also the influence which the principles had with regard to data rights. And you will find the principles with regard to data rights in part 3 of the Black Letter, which you have received in your documents. So what are data rights? Data rights are rights that are specific to the nature of data. So they're not like rights that follow from a breach of contract or tort or conversion of property. They're really specific to the nature of data. And maybe the most important data right is data access rights. And this is not just one right. I mean, data access exists on a spectrum, right? It can be just viewing or reading data. So this is kind of the bare minimum of data access. But it can go up to full data portability, and we see those portability rights now in a lot of upcoming legislation. So data access is by far the most important data right, and it's really data specific. But it's not the only data right. So the principles differentiate between 4 types of data rights. There's also rights to require desistance from particular harmful data use, a right to require correction of data, and also, but very exceptionally actually, a right to have a share in profits derived from data use. But as I said, data access rights are the most important ones, and they have been the most influential part of our principles. So what do the principles say about data rights, and in particular data access rights? Well, the principles differentiate between 2 types of data rights. So not just the types which I explained a minute ago, but also they differentiate between the rights in co-generated data and B, rights that have been afforded for the public interest. And I will focus mainly on the rights in code-generated data, because this is the part of the principles that's really been very influential also with regard to the Data Act. The principles coined the term code-generated data, and it's now widely used throughout the world, including in European Commission documents and many other documents of legislators around the globe. And so what are code-generated data? What is the idea behind it? Well, the idea is a very simple one, actually. It means that when you've had a share in the generation of data, this may give you certain rights with regard to those data, such as data access rights. Now, what does it mean to have a share in the generation of data? Well, this can mean many things. It can mean you are the subject of the information coded in the data. The data is about you. Or you are the owner or operator of an asset that is the subject of the information. So the data is about your land, your car. Or the data is generated by an activity of yours. You are driving a connected car, and that connected car produces terabytes of data. So this is also something that is really important, and this we will see that this is now being taken up by the Data Act. Or you're the owner or operator of a device that generates data, or you have produced or developed a device that generates data. These are all modalities of data generation, and depending on the type of contribution and the weight of your contribution, this share in the generation of data may give you certain rights. But it's not just that share, actually. This is not sufficient to give you the data rights. The principles differentiate between, or they identify rather, 5 different factors. And the share is just one of those factors that may decide about whether you have that data right or not, and whether it means just viewing the data or full portability or whatever what the modalities are. The other factors are the weight of grounds you can put forward for exercising that data right. And a lot of what you find in those principles, these are principles 18 to 23, by the way, is about those grounds, what the nature of those grounds is, and what the weight of those grounds is. But needless to say, it's not just the interest of the party that wants data access or wants to rely on a data right, it's also the legitimate interest of other parties, such as the controller against whom the right is exercised, or third parties. And also the legitimate interests of those parties are an important factor. And then it's also about any imbalance in bargaining power. And last but not least, it is about public interest. And it is those 5 factors that decide not only about whether a party should be afforded a data right, but it's also about what the data right should be, what the modalities, what the details should be. Now, this is the part on code-generated data, and as I said, this has been the most influential one. And there's also another chapter which is about data rights for the public interest. You will find those principles in principles 24 to 27. Now, this is a little bit different. This chapter is about a situation where a legislator has afforded in statutory law a data right. And we find those data rights now in a lot of sectorial legislation. We find it in competition law. We find it in other places. This is a little bit different. And so what the European Commission and the European legislator, because as Steve said, the act was just passed by Council and Parliament. So what the European legislator has now done is get inspiration from all those principles in fact, from the principles on code-generated data and the principles on data rights in the public interest. And when you look through the Data Act, you will find in all sorts of places kind of those elements which we designed in the principles, in particular as the Data Act is about data access rights and data portability rights of the owners or operators of connected products, such as connected cars, connected washing machines, you name it. So this is why the principles have been so important here in that regard. And that brings me to the third poll question, actually. So can we get the third poll question? Yeah, now you see the third poll on your screen, and US attendees, if you're seeking CLE credit, you must answer all 4 polls. So a reminder to US attendees, you must answer all 4 polls. And our question is, prior to today, had you heard of the European Commission's Data Act or the EU legislators' Data Act? You have 10 seconds to answer. Okay, so I hope you all ticked your boxes. And it's now my special pleasure to introduce another speaker, Maja Bogatay-Jancic. She's co-chair of the Data Governance Working Group for the Global Partnership on Artificial Intelligence, or short, GPI. Now, GPI is one of the organizations that has been heavily influenced by our principles, in particular by the part on rights in code-generated data. And so I'm looking forward to hearing what Maja has to say.
Dear attendees of this webinar on the impact of principles for a data economy and members of the American Law Institute and European Law Institute, my name is Maja Bogatay-Jancic, and I'm delighted to address you as a co-chair of the Working Group on Data Governance within the Global Partnership of Artificial Intelligence. Launched in June 2020, GPI is a multi-stakeholder initiative bringing together leading experts from science, industry, civil society, international organizations, and government that share values to bridge the gap between theory and practice on AI by supporting cutting-edge research and applied activities on AI-related priorities. GPI experts collaborate across 4 working groups on the themes of responsible AI, data governance, the future of work, and innovation and commercialization. Our own working group on data governance is co-chaired by myself and Jenny Tennyson. We aim to promote data for AI being collected, used, shared, archived, and deleted in ways that are consistent with human rights, inclusion, diversity, innovation, economic growth, and societal benefit, while seeking to address the UN Sustainable Development Goals. Over the past few years, we have explored the role of data in AI and developed a framework paper, ably led by Christiane Wendehorst. We have explored the role of data trusts and other data institutions and the principles and practice of data justice. With the Singapore government, we have explored the use of technologies that enhance privacy and other rights, and we are currently exploring the role of governments in sharing data to support the development of AI. Finally, Christiane leads our CoGen project, from code-generated data to generative AI, new rights and governance models in digital ecosystems. The project builds on your principles for a data economy. In its initial phase, we have explored 6 scenarios that cover a wide range of data, co-generators, and legal contexts, like collaborative, crowdsourced data collection, remunerated work, Internet of Things, social media platforms, and conversational generative AI. As the principles for a data economy describe, and as our research further details, co-generators in these scenarios are subject to a web of different rights, including intellectual property rights, data rights, and labor rights, which are currently brokered through terms and conditions, contracts, and licenses. We hope this research will help to make more concrete the principles for a data economy and make them accessible to new audiences, including embedding them within policy briefs that we share with the member countries of the Global Partnership on AI. On behalf of myself and my co-chair Jenny Tennyson and the whole of the Data Governance Working Group, we would like to thank you for your work on the principles for a data economy and the foundation they have provided for our research and co-generated data, and we look forward to future collaborations. Thank you very much and good luck.
Well, thank you so much, Maya. And indeed, the Global Partnership on AI, on which US, by the way, is part, has really built on those principles. It's one of those organizations that has fully adopted most of the notions of the principles, including the notion of data rights and in particular rights in code-generated data, and has now initiated this CoGen project, which Maya was talking about, and wants to launch another project that's equally based on the principles. So maybe just 2 words on the CoGen project. This is not to rewrite the ALI-ELI principles, not at all. It's about building on the principles and possibly exploring how the basic ideas developed in the principles can be utilized for other questions which the principles didn't tackle, notably the question of whether there is such a thing as collective data rights. The principles, when you read the comments, you will see it's already mentioned there that there may be such a thing as collective data rights. And now this CoGen project goes into this question and explores whether it's really useful and helpful to kind of take what the principles say about individual rights and make it work for collective rights. And this could mean, for example, that when you use speech data from a particular continent, such as the African continent, do then parties from the African continent or peoples on the African continent have an access right? Do they have certain rights with regard to this data? We don't know yet. The project is still running. Another question that is being asked is, can we use what the principles did on code-generated data? Can we use that for code-generated technology, in particular generative AI? So ChatGPT and all the rest of it, can we use it for that? So these are some of the questions that are now being looked at, but this is the future. We can't give you the results yet, but you see that the principles inspire also further work that goes beyond data transactions and data rights. And with that, I would like to hand over to John for the general discussion.
John, you're on mute.
Can I, first of all, thank everyone who has participated, or both on video and live, for a very fascinating discussion, which I hope has broadly interested those who are participating in this webinar. Now, as I said at the outset, what we are interested in are questions, and I think would invite you all now to think of questions that you would like to ask and put them in the Q&A box at the bottom of the screen. But can I address one of the points that's been raised? And it's really a nuts and bolts question as to how the project has come about and how the panels have been formed. Well, this project was one that took some time to think through, partly because it was dealing with an innovative area of technology where the law might be needed to be developed, and partly because it was the first collaboration between the European Law Institute and the American Law Institute. And so after some careful planning as to the kind of product that we might produce, both organizations decided they would use their own structures to get as broad an input as possible. Now, I say use their own structures. Their structures are very similar, and that's because the ALI have been so successful then over its 90-year history, today its 100-year history, that very many of the ways in which the European Law Institute was created and established follow what the ALI did. And the first important contribution to the way in which the organizations work is to ensure that you get a good mix of judges, you get a good mix of academics, and you get a good mix of practitioners, people who practice the law as advocates or as transaction lawyers. And so, as the organizations have that basis, it was thought, well, we must ensure this is reflected in the committees. Secondly, each of the groups, each of the organizations has an advisory committee for a particular project and a membership. And so, speaking now entirely from the European Law Institute's perspective, we looked for as wide a perspective as possible. Now, in Europe, we have to take into account much more the division between the different civil law traditions and the difference between the way in which the common law has developed and the civil law traditions, though it may be said that these are diminishing more and more as the years go by. So we first looked for a good balance there. We then looked for a good balance across the professions, and we looked for a good balance of academics and judges. And we widely publicized what we were going to do, and we'd hoped that anyone who was interested in the direct participation as an advisor would let us know. But there also, the European Law Institute has a membership committee, which it sets up for each project. And on this project, the membership committee was active, and any member can participate in that way. So we've tried from, as I said, from the European Law Institute's perspective, but very much having the privilege of attending meetings with the American Law Institute, both aim to get as broad a cross-section as possible to ensure that the input comes from as many different aspects, and in the case of Europe, different legal traditions as is possible. But I hand back now to Steve to see if he can add to what I've said, particularly as regards the American Law Institute.
Thank you, John. And as John has described, the American Law Institute engaged in a very similar process. We sat down and looked at projects that were in the same or similar areas, such as software contracts, for example, and looked who had been active in those, spoke to people. We did not limit ourselves necessarily to people who were already in the American Law Institute, as the ALI does for every project. It wants to get, as we've been saying over and over again, broad input, because none of us think we have all the answers, and it's terrifically important to find out what other people, whether they're judges in academia, practicing lawyers, or in some cases not lawyers at all, and get their input on what the issues are. Will the proposed solutions work in real life and in the real world? So we engaged in much the same process. The ALI, similar to ELI, for each project has an advisory group, and then what is also called a members consultative group. Anyone is welcome to make comments. The drafts are posted, and in this project, drafts were posted both on the ELI and ALI websites. Comments came in. The reporters take those comments very seriously, consider them. At the ALI, Neil and I have been involved in more projects than we can count. And it's always very reassuring to see that as comments come in, whether Neil and I are holding the keyboard or just throwing in comments, that people who are involved in the project really do care, understand that they don't know everything, and read the comments, take them into account, make adjustments as appropriate. And it's an iterative process, like so many things we do. So there was, as John and I have both said, a very specific and deliberate effort to gain wide input and to be sure that everybody listens. And Neil and Christian, any comments on that, or more generally?
Well, I think exactly as you said, it is this mix of different people, of different bodies within the two organizations that makes the work so rewarding and also so successful. So it's not that just a group or like Neil and I sit down and invent all this. It is really the contributions from if you like, hundreds of excellent people from all sorts of professional backgrounds that contribute to this work. And this is how the ALI has become so influential. And this is also how the ELI works.
Yes, I'd just like to add on that we benefited not only from comments and suggestions made by experts in the field, but also very often by comments and reactions from people who are not experts in the field, but are very good at some other field that perhaps relates to or interacts with the areas we covered. And very often the perspective, the fresh perspective that comes from people who ask questions of that sort is particularly useful. Christiane said that we took into account all of these questions and benefited from them. Which is absolutely true. In fact, we kept a list of every comment that was made to us during the various types of consultation processes, appearances before, on the ALI side, for example, before the Council of the American Law Institute and at the annual meetings of the members. And when we would prepare revisions to the drafts of the principles, we made sure that we were satisfied that we had either adjusted our draft to take into account the comments, or that we were confident that the draft itself addressed those comments. But the comments and suggestions were taken very seriously throughout the process, and it certainly made it a better product at the end.
Well,
Neil, do you want to address? Oh, go ahead, John.
I was going to say, just thank all the answers. And I was going to do what you're about to do, which was ask Neil to read out and address the next question that comes, but possibly amplified by explaining how the principles are meant to work on a transnational basis when on some areas the laws differ.
Well, thank you, John. The third question, which I think many of you can see on your screen, is to what extent do the principles consider competition policy issues, data being an asset that is valuable for commercial purposes. As a general matter, we did not explicitly address competition policy independently of contract principles, partly because as a general matter, we stayed away from regulatory issues since the regulatory policy of individual states, or in the European context of the European Union, is very much a matter of public policy that's educated by and affected by many concerns, not all of which were susceptible of the type of analysis we're providing here. There are two other areas, in fact, in addition to competition policy, that we generally stayed away from. In fact, the two areas I'm going to mention were really sort of borders to our project that we agreed not to cross over. The first one was data privacy, data protection issues. That's been so extensively dealt with in other contexts and by other organs. We did not want to give the impression that we were rethinking those issues that have been so extensively addressed. The other set of matters that we did not address for a similar reason is intellectual property principles, intellectual property law. We're not setting out to address questions of the extent to which data can be the subject of intellectual property, and if so, how those rules work. We have national laws in that area, we have international conventions, and again, the purpose of our work was not to repeat the application of already agreed upon legal principles in those areas, so much as it was to fill the gaps in contract principles and other types of principles where we thought we could add value. So thank you very much for the question. I hope that is an answer that will help you see what we did in this area. Thank you.
Yeah, and let me add to Neil's comments. When the germ of the idea of this project first came along between ELI and ALI, Christiane and I worked up what you might call a term sheet or a little feasibility paper. And as Neil said, we very quickly decided not to cover the privacy questions, the intellectual property question. And we didn't, this is a double negative, we didn't decide not to cover it sort of by accident. We placed boundaries on ourselves and very quickly concluded that we didn't need to cover those, and it would the project itself was big enough. And when I went before the ALI Projects Committee to propose its approval of this project, my first sentence was, this is not a privacy project, not another privacy project here. We're looking more at commercial questions involved in these transactions. And I strongly believe that those initial decisions were the right decisions. Christiane, any thoughts on that? Or?
Yes, I would fully confirm that. And I mean, making competition law data proof, if you like, is a very important task. It's a task that's being taken on by many jurisdictions around the globe at the moment. Many countries already have adapted their competition law to data, but this was not within the scope of our project. Having said that, it is in particular part 3 that does refer to competition law in various places. So when you look, for example, at Principle 20, there is reference to such things as anti-competitive lock-in effects as one of the justifications for having a data access right. Or if you look at the rights in code-generated data in general, you know, these are principles that need to be operationalized within some existing legal framework, which can be contract, which can be competition law. So what you find in part 3, in particular on the code-generated data, this is often something that is kind of operationalized by way of very traditional competition law tools. So the principles have competition law in the back of their minds, but it's not about competition law. And as Steve said, I think it was a very wise decision for us not to try and rewrite all these traditional areas of the law that, let me repeat that, need to be made data proof. We need to make competition law data proof. We need to make tort law data proof. We need to make property law data proof in a way. But so this is not what we did in our project, and that was a very wise decision. Otherwise, we still wouldn't have finished up to the present day, and there would have not have been this very beautiful volume for Steve to hold into the camera.
Can I just add one final observation? It does seem to me that one has to look at this as principles that are in effect commonly workable across any legal system. And we know that people have very different political and legal views about competition law, about privacy, and in each system produces different remedies, different rules of evidence. This is a core of principles that neatly comes down and fits within a system. And therefore, that's why it can be said to be transnational in its concept. Now, that's, I think, the answer to that question. Can we go on to another one? And maybe, Christiane, you'd like to read out the next question.
So the next question on the screen, which I see, is by Miklos. Is it appropriate to develop specific and in particular stricter rules for when AI uses data? Does this use mean a higher risk? Well, this question is a little bit difficult to answer. So first of all, I would say that what we did in the principles about data transactions and data rights applies irrespective of whether the contracting parties or the parties in a data rights relationship use AI or not. AI is just a tool which people use for concluding contracts of whatever kind, be it a data contract or be it a sales contract about a car. I don't think AI complicates the matter in this regard, but of course, as AI is a tool that works only with data, input data, and also before it can use input data, training and testing data. This is where AI poses particular problems and issues and risks. And these are the risks that are now being addressed by several legislators worldwide. And of course, knowing that you're from Europe, notably the European legislator with the Artificial Intelligence Act. So this is about the specific risks of AI, where AI is used, for example, for credit scoring, for recruitment software, and similar high-risk activities. But this is not exactly what we deal with in our principles. So let me repeat, in our principles, the principles about data transactions and data rights, they would, in our views, work independently of whether or not the parties make use of whatever technology, including AI. I hope, Neil, that you would agree with it, or would you disagree?
I agree fully with what you just said, Christiane. The question that was posed to us is an extremely important question for the world in terms of how data is used and the new and in many ways unprecedented challenges that come from artificial intelligence using the data. Artificial intelligence is a jargon term. It sometimes promises more than it delivers, but one thing it has delivered is high speed, massive use of large amounts of data in ways that are not always susceptible to the same types of guardrails and safeguards that other types of uses are. This is an area that's developing. The thoughts about how to properly reduce risk are still developing. Important area, but not the subject of our project, partly because it requires a different type of approach, different type of regulatory viewpoint, perhaps, and different types of expertise, not all of which were represented in our project. So I think we fully agree.
And coming back to Ancitrol's work that was presented by Anna Jubin-Brett in the first video, Ancitrol now addresses both. So they address data transactions, building on our principles, and they also address automation and contracting. So these are the two pillars of the new work of working group number 4. And so it's very important, I think, to keep the two questions apart. In the one case, the one scenario, data is the object of trade. You have a data supply contract or a service contract about processing of data, or you name it. And in the other situation, you use artificial intelligence for concluding a contract or possibly for performing a contract. And it's, I think, really, really important that Ancitrol addresses both. But you see from that division that the two questions are really a little bit different.
So I think that's right, and I think that Ancitrol recognizes that those are different questions that have different types of answers. They're both being addressed by the same working group within the commission, but at this point it appears that it will be two separate products, one for automated contracting and one for data. The Ancitrol project, as has been stated already, is largely in many ways inspired by and certainly guided by our work here in the ALI-ELI principles. And Ancitrol, of course, is an organ of the United Nations. It's a commission of the General Assembly, and as a result, the members of the working group are not individuals. The members of the working group are states that are elected, and as a result, they bring us a slightly different perspective, even though a high percentage of the states that are members of UNCITRAL are, of course, represented by members in the ALI and ELI. The result is that they are taking, they're paying close attention to what is in our principles, but approaching them sometimes from a slightly different angle, organizing the answers a bit differently. But for the most part, perhaps not 100%, but for the most part, having draft answers that are largely quite consistent with what we have in the ALI-ELI principles. And the result of this can be to take our principles and give them an even broader global effect by having them be the product of a commission of the UN, which of course represents essentially the entire world.
Well, now, thank you all very much. There's a further question taking us into a slightly different area, which is to do with choice of law. And the question asked by Nicholas Maringo is, can you talk a bit about data storage, location of data, when considering choice of law? Christiane, would you like to start the answer to that question?
Happy to do so, even though I will very quickly refer to Neil, who is the absolute expert in that field. So we're probably talking about principle number 40, so which is the last principle in the black letter, which you find. And this is about a choice of law questions. You know, what is the applicable law when you have an issue arising about data rights or data transactions? And so principles 38 and 39, they describe in general, you know, how do we determine the applicable law in a cross-border, be it interstate or international setting. And principle 40 now clarifies that the location of data storage plays an extremely limited role in that context. Because data can be moved around the globe within fractions of a second. It doesn't have to be stored in one place. It can be stored in different places, and different parts of the data being stored on different territories, and again being assembled and split again within fractions of a second. So this is why the location of data storage isn't a very appropriate connecting factor for choice of law purposes. But principle 40 also explains that there are certain situations where storage location may be relevant, such as where you have a question that specifically relates to storage or to rights in the medium, because this is about the storage, or this is about the territory where the storage medium is located, or as a residual choice of law a factor where you have no other possibility basically to determine the applicable law. But I'm sure Neil has a lot to act and will correct me if that was wrong.
Well, thanks so much, Christiane, for such an encyclopedic answer. Indeed, I have very little to add to what you stated, except perhaps for those who have the principles in front of them and can easily access it, to draw your attention to Principle 40, where paragraphs 1 and 2 basically answer the question that was posed. And paragraph 1 is really the key here. That the location of the storage of data is relevant as a connecting factor only when the issue in question relates to storage or to rights in the medium. Because after all, in the era in which we operate now, where we have access to data and in fact really have no idea where it is stored in a physical sense, and in the vast majority of cases, with the redundancies that are created by backup systems and transmission systems and the like, it's likely to be stored in more than one medium, in more than one location. The almost coincidental happenstance of where the data is stored bears little or no relation as a connecting factor to the types of questions that we address. And so for the most part, the storage location has very little relevance. As we say in paragraph 2 of Principle 40, the location of the storage can be relevant as sort of a residual factor, as a tiebreaker, if nothing else resolves the matter. But in terms of an important connecting factor, one that we think should determine choice of law, the answer is generally speaking, no.
Could I just add one brief observation? One of the interesting things about data, about digital assets, and about electronic bills of lading and other documents of title is that it is increasingly seen as being important to try and ensure we have uniform laws, because the traditional way of looking at something through conflicts of law becomes incredibly difficult. It's particularly important as regards property, not getting into the debate as to whether data is property, but I do think that's why these are of overriding importance to everyone, that we agree on core principles. So under whichever system you litigate, you ought to get the same answer. Now, we must pause now because we're reaching the end of the time allotted. But before addressing the fourth poll question, I was going to ask Steve if he'd like to say something about his experience of this project and in relation to any future such projects.
Thank you, John. And one brief comment on the part we just discussed, which is why we've been emphasizing throughout this presentation the importance of coordinating the approaches, whether it's UNCITRAL or the European Commission or the principles or ELI or ALI. And if we're successful in that, if all the organizations are successful, then choice of law doesn't matter. And Neil wasted all that time drafting those provisions. And that's our goal, is to waste Neil's time on choice of law questions. As to the future, the ALI and ELI each believe, I think it's right, that this has been a successful project. It's produced a very useful work product. I'll hold up the book again that people will be able to use. It's already been put to use and implemented in various other projects. As you'll see some of them listed in the guide that's part of the material. So ELI and ALI have been exploring further projects that we might engage in. And it's an interesting process because one has to find a project that both organizations are interested in, that both organizations think is a feasible project that can be accomplished particularly on the ELI side with both common law and civil law jurisdictions, which have somewhat different approaches, but we are working up some stuff. One idea is on biometrics, areas that we think are of interest, that are cutting edge. Maybe artificial intelligence will work its way in there, but we have definite plans for ongoing projects. And each of the organizations, I think, has been extremely satisfied on how this project went. And on a personal matter, it's been an absolute pleasure to work with Christiane and John for the first times, I guess. And Neil I've been working with for 30 or 40 years, so I don't have to say that, but not on this project, happily. So John, I think that there definitely will be future projects, and we're actively, collectively, ELI and ALI developing those projects, and stay tuned for more of that.
Well, thank you very, very much, Steve. And before I reciprocate, it just shows how the Europeans are learning something about the way continuing education works in the United States. I must ask the fourth poll question. So could this be put up? It's the final one for the US attendees and reads, after attending this webinar, will you reach for the principles in your work, teaching, or other projects? You have again 10 seconds to answer. Thank you. Now, before turning to those closing remarks, might I say to those in the US on the webinar who'd like to earn CLE credit, please don't forget to fill out the form that was provided along with the other course materials and follow the instructions on that form to submit it for credit. I think those remarks show how jointly we've become engaged in this project. But may I conclude by saying three things. First, an enormous thank you to those of you who have attended tonight to learn or embellish your learning about the principles for a data economy. I also wanted to thank all of those who've participated by providing the videos, which show, I think, how widely important these principles are. And of course, my enormous thanks to Christiane and to Neil, above all, for the huge work they put into this project and for the brilliant answers they've given tonight. And to say, finally, what a great privilege it has been to work with them all, and in particular with Steve over these years. I very much hope that these projects will continue and that we can achieve a goal of trying to make certain, for the benefit of us all, that principles of law that are essential to products that operate globally are the same, because it's in everyone's interest that that is so. But again, my thanks to everyone, and my pleasure at being and privilege of being able to join with you this afternoon, or as it is in Europe, this night. Thank you.
Let me add just one further comment. I'd like to thank both the staff at the ELI and the staff at the ALI who organized this, who kept us organized, who had great ideas on how best to present the information in a way we hope was accessible and useful for people, and brought us through to this point. It was very smooth, very well organized, and both logistically and content-wise, they did a great job. So thank you very much.